Can come to order. We will get started. Welcome to the Senate Judiciary Committee. We are going to start with a word of prayer. Senator Steele, would you like to open us up in a word of prayer? All right. What's your mic number? 14 or 15? 15. All right.
Please bow your heads. Heavenly Father, thank you so much for this beautiful day. Thank you for an opportunity to continue to serve you and the great people of the state of Georgia. Father, please keep our minds open and our words few as we hear these great bills presented to us today. In your name we pray. Amen.
Thank you for that. As we collect the sign-up sheets, if you want to be heard on a bill, please come sign up. We have a pretty aggressive agenda and a 1 hour, maybe 55 minutes of time to hear all these bills, so we'll see how far we get. Let's start. Justice Bethel, do you mind coming up and bring Ms. Duncan with you? If you'll introduce her to the committee, and we have one special guest, well, a bunch of special guests. But I want to let her say hello to us.
All guests are special, right, Mr. Chairman?
That's right.
Thank you so much. Thank you, Mr. Chairman and members of the committee. I do wish to introduce Dabney Duncan to you. Dabney is a senior at the University of Georgia. She's a Dunwoody native. She has interned with a former member of this body, not meaning this committee, because I don't think they ever let Buddy Carter on Judiciary, but Congressman Buddy Carter, who was a member of the Senate. She's interned in his office and has an interest in attending law school after I think she plans on a gap year where she'd like to study a little more about her opportunities in the law. But she's distinguished herself in Athens, and she's just come to see good government in action. So.
Thank you.
Well, you pretty much covered it. But I'm really excited to be here, and thank you all so much for letting me come and learn, and I'd love to meet anyone and everyone, so thanks.
Thanks for joining us. I may call upon you for some expert testimony at some point. So,
I'll be ready.
All right. Thank you, Justice. Do you have a bill today, Justice Bethel?
I think Mr. Leverett has.
Okay. Well, thank you for being with us regardless. Our judge of the day. Our justice of the day. All right. We're going to start a little ways down the agenda with House Bill 392. Chairman Martin. Let's give us a second to pull the bill out of our packet. I know you got to go chair a committee to hear some Senate bills. We're working off LC 280667. This is the version that passed the House. The floor is yours.
Thank you, Senator and members of the committee. I'll be real simple with this and stand for questions because I know you have a packed agenda. This bill seeks to clean up the transition that Georgia made last year. The voters approved through a constitutional amendment from what we have as a tax tribunal in the executive branch and administrative court to moving that court in the judicial branch. This changes some dates and provides for a more seamless transition of the cases from the tribunal to the judicial court on the last page of the bill on page 3. And I believe I would stand for any questions. I mean, that's basically what it's done. You saw the bill last year and passed it. There was the enabling legislation, and the constitutional amendment did pass.
All right, any questions from the committee? No one signed to speak on the bill. What's the pleasure of the committee? Motion do pass from Chairman Watson, and a second from Senator Steele. Any discussion? All those in favor of the motion, please raise your hand. It is unanimous. Is this mine to carry?
Yes, sir. If you would do us the honor, we would love to have you take this to the Senate floor.
Yes, sir. We got this done last year, barely now by the voters of the state, but we got this done last year.
I think it might have been one of the most misunderstood questions I've ever seen written.
I think so. Maybe in hindsight, we should have written it a little differently.
I am thankful it passed. I believe it'll be good for the taxpayer.
Thank you for your work, Chairman Martin. All right. Back on the agenda, House Bill 86. Chairman Leverett, come on up. We were working off of LC 473171, the version that passed the House. The floor is yours.
Thank you, Mr. Chairman. Thank you very much for putting the bill on. So good to be back here at the Vista Lake Club again. I just feel like it's old home week. You know, it's nice to see you all again. I hope I won't have to be quite as consistent and repetitive to bother y'all this year, but this bill is I appreciate very much you placing this on the agenda. This is part of our legislative efforts to reform the structure of pay of our state's judges. So this bill deals with statewide judges, the Supreme Court, Court of Appeals, statewide business court, and it's interesting that as a segue, the tax court once it gets up and running. So we're basically trying to reform the structure of pay for them. And we are taking the code section 4574, that's in section 1, which sets out a specific salary amount, a dollar figure for pay of various state officials, including judges that are state employees. And we're striking the numbers and replacing that with a cap. So we're removing the affirmative obligation to pay a set amount from the code and replacing it with a maximum that cannot be exceeded. And that cap is expressed not as a dollar figure, but as a percentage of a baseline or an index, which is the pay for United States District Court judges up here in Atlanta 2 years ago, because we think that'll allow appropriators some time to plan so they know what the max is from year to year. And we just simply try, as part of the sort of reform effort, to impose what I guess say is sort of a hierarchical structure to it. If you look on page 9 of the bill in lines 202 to 210, that's where we say what the base salary is. We define that as what judges in the U.S. District Court for the July 1 of the second preceding fiscal year received. And then we provide that the cap, not the obligated pay, but the cap. This is not an appropriations bill. The cap for justices, the Supreme Court is 100% of that base amount. Court of Appeals is 99%. Statewide business court is 95%. And then in section 2, because it has a different effective date, because the tax court won't be effective for a little while, we add them to the list and set them also at 95%. And then in the section 3, it just deals with the effective dates. So if there is some appropriation that would be effective as of June 1, 2025, section 2 would become effective. If not, it would be July 1 of this year. And then section 2, which is for the tax court, will become effective July 1 of 26. So that's basically the bill. I hope to have companion legislation. Well, you've already heard one bill. Again, thank you, Mr. Chairman. The retirement bill that was sort of part of this initiative, and then the bill for Superior Court judges, which is a little more complicated, will be next week, we hope. And that's the bill.
All right, you do have questions from the committee. Chairman Cowsert.
Thank you, Mr. Chairman. If I could ask a couple. So right now, I mean, this could be a pay cut bill. We could cut them to $50,000 a year if the appropriations bill next year does that.
I would urge you not to do that, but that's what the committees could do, yes, sir.
The Court of Appeals and Supreme Court like this idea of being fluctuating every year. They can go up and down, whatever the mode of the economy, and if we have a recession and.
Well, there is the constitutional limitation on changing salary of a judge during their term, although I don't think that applies once their term is up. But this was the Judicial Council approved this concept several years ago. We tried last year, couldn't get it across the line. We're back trying again, hoping we'll be successful this time. But the judges very much do support this, and I think Justice Bethel is still in the room, and he could address that to the extent the committee would like to hear from him.
Well, Justice Bethel's been in the legislative process, so I guess he knows the dangers of that can of worms, but
well, and I think also to be quite frank about it, I think because some of the members of our judiciary were once members of this branch, they know that we are sort of jealous, covetous old sinners when it comes to our appropriation authority, and we don't like to have it restricted. So this bill, it would restrict it in the sense that we can't go over a certain amount, but we felt like that would be a restriction that was somewhat unique and would be well received.
All right, and if I could ask just two more questions. My understanding is the federal district court judges are now set at roughly 242, 240,000, something in that range.
Yes, sir.
So we're theoretically allowing a raise from 174.5 up to 239,000 a year.
You would be permitting it without mandating it by approving this bill.
And has anybody looked and thought, this is the first time I've seen a sort of a layout of all the other constitutional officers' pay. I mean, is there some reason why a judge ought to make $50,000 more than the governor?
Well, I don't know that I would say, judges must be paid any set amount. I think the concern is because judicial salaries, especially in the Atlanta area, have gone kind of crazy over the last few years. And even in other places across the state, you are seeing some attrition. You're seeing judges leave, I think at a somewhat higher rate than we traditionally have done so. And when we, even at the Superior Court level, I've always, a lot of my fellow legislators says, oh, every time, they open up one, Lord, they're lining up out the door of the courthouse trying to apply. They don't have time to interview all the applicants. But I would suggest that has been the case, but that's not so much the case anymore. I've just heard anecdotally, I know in my circuit, we had a judgeship open, only one person put in for it. It was, as Judge heard you say, that's the only way to run, unopposed. I've heard of other judgeships where there was an opening for an appointment, and there was only one person who put in for it. So I think there's just a concern that, as important as every branch of government is, and all of our statewide officials are, we're not competing with the legal market usually for those positions, and here we are, and we just need to make sure we're paying a salary that's commensurate with still attracting quality candidates for those positions, because you've appeared in front of judges, you know how important that is.
They're very important people in my life. Thank you, Mr. Chairman.
They can make your day and they can ruin it.
Senator Rhett.
Thank you, Mr. Chairman. Judge Strickland.
Justice sounds better. But I guess Chairman will work for today.
Just a easy, quick question. Most judges, when they leave, is it because of retirement, or?
Well,
I don't know if you know it or not.
Recently, we've seen a number of judges leave the appellate bench, and they've gone to big firms. They've gone to jobs where they make significantly more money. At the trial bench, which is not this bill deals with statewide judges, it's sometimes because of retirement, it's sometimes because of family pressures, it's sometimes, I've heard lately of people leaving to continue working, but working in the private sector. And part of the reason we feel is because of the salary disparity. It's not that we don't pay them well, we just don't pay them well compared to what's available to them. Thank you for the question.
All right, no other questions from the committee. No one else is signed up to speak on the bill. What's the pleasure of the committee? Motion to pass from Judge and Leader Hatchett. Is there a second? Second from Judge Kennedy. Any discussion? All those in favor of the motion, please raise your hand. It is unanimous. And who is carrying the bill in the Senate?
Senator Hatchett.
Justice Hatchett. All right.
Justice Hatchett.
Thank you.
Thank you, Mr. Chairman.
Thank you for your work. We'll see you again soon.
All right. I look forward to it.
The Chairman Crow come back in the room. All right, we're going to go back. House Bill 270. Come on up, Representative Reeves. Other than Chairman Leverett, you have probably the second most bills typically in our committee. Maybe not this year, though.
3 good ones coming.
Just 3. All right, we're working off of the version that passed the House, LC 481536. Is that what you have?
That's it.
All right, the floor is yours.
Thanks, Chairman Strickland, members of Senate Judiciary. House Bill 270 fixes a problem that came up at the appellate level last year in the Mancuso versus Cadles case. That was a decision in January of 2024 by Judges Barnes, Land, and Watkins. And what that showed us is in Title or Code Section 911.4, that is the method of serving any civil lawsuit. You can have a private process server. However, under Code Section 44.751 relating to dispossessories, there's no similar provision for private process servers to serve evictions, which of course we've learned in recent years that's one of the highest volume cases in Georgia, particularly in metro Atlanta and larger counties, is evictions. There are large backlogs, and so the system depends on private process serving of evictions. So this bill gives a statutory basis for private process servers on our dispossessories in response to the Mancuso versus Cadles case. I learned about this actually in Judge Hollyville's courtroom in Henry County. I think you and I had some calendars together as I was working on a case in Henry County. It was not my case, but I heard her explain that case, that you can't have good service in an eviction anymore under that case last year. So this case restores that jurisdictional basis for service via private process server. There is still due process on the service because a judge either has to have a motion and an order appointing that private process server or a standing order appointing that private process server. So you've still got judicial supervision of that type of service, and this basically puts the law back to where it was for 100 years and the way everybody thought it was before that court decision that interpreted the law.
All right, you do have questions to the committee. Senator Parent.
Great, thank you, Mr. Chairman. Thank you, Representative Reeves. Quick question, because I had conversations with a couple folks before coming in who are interested in this bill on behalf of entities that they're representing. And so I just wanted to make sure I'm clear and that
Sure.
I understand what you're thinking.
You bet.
So essentially you have to be certified and then you would be on a list, which is where you become approved.
That's right, Senator Parent. I had an opportunity to speak with Ms. Apley about that concern. The language in the bill says approved private process servers, but Code Section 19-11-4.1 provides for certification of process servers. So just like in 911-4, you have the judges approve the private process server for this particular case, but they've got to be one who's certified. I talked to the property owners who brought this bill. They have circulated that approval language with some judges and courts, and they believe that's the right language, and it's going to be on them to come back for a cleanup if it's not the right language. So we would ask for that approval language to remain in place due to the statutory certification process in another statute.
All right, I understand. Thank you for walking me through it.
Thank you.
Senator Steele.
Thank you, Justice Strickland. Representative Reeves, good to see you, my friend. We have another bill coming up. It's going to be presented potentially shortly in this committee hearing. I notice you're also a signer of. Thinking of unintended consequences, we're going to keep adding more bills, adding more layers of protections, and naming different career fields of people having increased penalties for assaults on these. Obviously, process servers are subjected to this as well. Sheriffs already have protections. Process servers probably are not on that list. So can we expect another bill or another amendment to offer some layer of protection against those that would seek to harm these people?
Or private cause of action to support them.
There might be a bill about that floating around.
You and I overlap in a good part of Gwinnett County. I'm glad to talk to any private process servers who have that, but I have not heard from anybody yet on that. And I talk to a lot of them frequently, but I'm glad to work on that if they have a concern.
I'm just thinking proactively. I don't know any building officials have been insulted lately either, but we got a bill on it. So
they've been serving evictions for a long time, so this would get them back into the business of serving those evictions. And if they want to talk to us about legal protection, I'd be glad to talk to them.
Cool. Thank you.
Any other questions from the committee? All right, there's one person signed up to speak on the bill, Miss Elizabeth Appling. If you want to come on down. You're waving? All right, for the thousands watching at home, she waved. She spoke with the author and Senator Parent about the issue already. All right, no one else signed up to speak on the bill. What's the pleasure of the committee? Motion to pass from Senator Rett. Is there a second? Second from Senator Parent. All those in favor of the motion, please raise your hand. It is unanimous. And who is carrying the bill in the Senate?
Floor Leader Senator Hatchett.
Hatchett, he's busy. Another governor's bill. All right. Thank you, Representative Reeves. We'll see you soon. Thank you.
Thank you.
All right, House Bill 483, Representative Prince. Am I right? This is your first time in front of this committee?
That is correct.
Welcome.
Justice Strickland.
My old friend from the House. Good to have you over here in this capacity. Did you ever think years ago you'd one day be over here and I'd be chair of this committee? Can you believe that?
I didn't think that far. I don't think that far.
Yeah, sad times in the Senate. All right, we're working off of LC 481558. Is that what you have?
Yes.
Yes. And this is the version that
committee
passed the House?
substitute. Yes.
All right, the floor is yours.
All right. Basically, again, thank you, Mr. Chairman and committee members. House Bill 483 basically provides protection for code enforcement officers, much like we did last year. House Bill 1033, I think we had utility workers. Basically, it's the same bill, just adding utility workers to it, and the different parts of assault just goes up the more crime they commit. So,
Any questions for Chairman Prince from the committee? I thought we might get one from Senator Steele. Go ahead.
Thank you, Chairman. As we just referenced in 270, I work around inspectors every day outside of being here. I have never heard of there being this situation of rash crime being caused against building officials. I've never heard them complain about it. I speak to the building officials convention. Or is this another bill that we're passing to add penalties? Because if somebody's going to assault a building official, I don't know that they're going to look at this bill that we're passing today to make them think twice about whether or not they're going to take a swing at somebody or cause some sort of aggravated assault. I'm just wondering your experience with that.
now, I personally haven't had any experience with it, but it has been some in our. I'm from Augusta, Richmond County, and we have some code enforcement officers going out to enforce codes. After Helena, we had to build back a lot and we still are in Augusta, in that area. And some of the buildings that they have to build back has different codes now because they were so old. And what we have had is some folks being threatened to come on the property, as well as one or two getting assaulted. And again, this is just not in Augusta, but this has come from across the state. So the answer is yes, this is something. I'm not sure how often it happens, and I don't think they will probably look at this code or this bill to know, hey, I need to stop or anything like that. But I think once it gets out that these folks are out here doing a job and that we need them to do, it could prevent folks from assaulting them.
So we're treating, and we're already having code about utility workers.
You did that
so
last
they're
year,
protected, right?
1033.
Now
Yes,
we're
sir.
adding code. I'm just wondering who's next after that.
I'm not sure, but if it's something that I think we need, well, I'd be more than happy to bring that as well.
I just figured let's just get everybody at once, right?
I'm not sure who everyone else would join in on this, but I agree with you with that as well. I do agree with that.
Thanks.
Let's get them all.
What about pool installers? Maybe we should include them.
They could not be
Okay, all right. Senator Rett?
No, I was going to say I think it's a good bill because I'm working with the new city of Mableton, and they work with code enforcement, trying to build one of their things they work with, and just you'd be surprised how many people are threatened or attempted assault because perhaps they didn't like the way they came and cited them because they have too many cars parked in the garage, a driveway, things like that. But I think it would also be a good deterrent just to protect them with this bill you have here.
And that's how this came to me from an incident.
Any other questions for Chairman Prince? Leader Jones?
Thank you, Mr. Chair. And just to clarify, what you were saying was, I think in the Augusta area, that the assault was actually because of the job that they were doing. So you could connect the assault to the job that they were doing. Is that correct?
That is correct, sir.
Okay. All right, thank you.
Any other questions from the committee? No one else signed up to speak on the bill. What's the pleasure of the committee? Motion to pass from Leader Jones, a second from Chairman Cowsert. All those in favor of the motion, please raise your hand. It is unanimous. And who is carrying the bill in the Senate?
Hopefully Chairman Cowles is there.
Chairman Cowsert. He hadn't said no. All right. Thank you. Good to see you. Let's go back to, hold on one second. All right. We're going to go to House Bill 618. Representative Campbell, come on up. We are working. Working off a committee substitute LC 520832. Is that what you have?
32S.
Yes, that's right. All right, the floor is yours, and tell us when you present the difference in this bill versus what passed the House as well.
Okay, this bill is basically what passed the House.
Okay, so it's not a committee substitute. This is a substitute from the House.
There was a couple of small things.
Yeah.
Suzanne Brody, do you want to comment on that?
May I answer?
Sure.
So the difference in the bill you see before you and the bill that passed the House is the product of conversations with our friends, the Realtors, giving them a longer runway for implementation, pushing it back to January 1st, 2026 versus at signing of the governor, and also clarifying that this applies to residential properties.
Was there also something about the disclosure requirement with the Fair Business Practices Act as well that was changed?
Correct. Nothing in this section shall require the seller to do independent investigation or inquiry.
Okay. All right. Go ahead.
So this bill is about requiring any seller of real property, which in this case is residential, is homes, to make certain disclosures regarding to flood damage, the history of flood damage of that of that house. A renter automatically, by law, they're required to disclose to a renter the flood damage history. A buyer, that is not the case. It is not required by the owner or the seller to require the flood damage history, and that's what this bill is about: is making those two equal, putting the buyer on the same level as a renter. In Georgia, renters already have the right to flood disclosure. Georgia law requires landlords to reveal a property's flooding history. Georgia home buyers deserve the same right. HB 2618 would amend Georgia's law to require disclosure of flood history. And just a few points just to wrap it up. Purchasing a home is a major investment for hardworking Georgians. Studies show homes that flood once often facing repeated damage. While renters benefit from flood disclosures that require landlords to reveal a property's flooding history, many prospective homeowners are left uninformed about their property's past flooding incidents and associated risk. This bill will correct that oversight.
I know we're going to hear from the realtors in a minute, but is this something that's already currently on their forms that you see in the realtor forms? Are you going to address that when you come up, Jeff? Okay, we can wait on that. Any questions from the committee for the author? There's some people that are starting to speak on the bill. We can take. All right, Chairman Calzert.
Thank you, Mr. Chairman. So I noticed you've put this under the Fair Business Practices Act, and you've included in here that any private causes of actions may be pursued. Can you familiarize us with what new torts you are creating here? This would create a new tort, correct? That you can sue somebody if they fail to disclose? What are those private remedies that are provided under the Unfair Trade Practices Act?
This is why I brought Ms. Brody here to be with me today. So I'm not sure what that is.
I am pulling up that code section right now. If you will bear with me, and it is possible our friends the realtors have.
I'm looking at line 49 on page 3, and all private remedies available under such part shall be available with regard to any such violation.
And the realtors are happy with what we have here, so they're on board.
They need to know, because they're opening themselves up for lawsuits, working in conspiracy with the homeowners if they're listing these properties that don't disclose.
The civil penalty is capped at no more than $25,000 per violation.
Okay, does that include attorney's fees as well?
I am reading the code as we speak. This portion of code I have before me does not specify.
Okay, all right, thank you.
Any other questions from the committee for the author? Senator Watson.
All right, so for those us non-lawyers on here, so this opens the seller opens them to a lawsuit, and the most he could lose would be $25,000, and we just are not clear on the legal fees. Is that correct?
Correct, and that's only if they willingly and knowingly do not disclose this information. So if they do not know that their home has flooded previously, then they are not held responsible for this.
You mean if it were flooded, 2 or 3 owners before, you're going to be responsible for that?
If it flooded and they are not aware of the previous flood damage, because of course it's not required to be disclosed at this point in time, then the sellers cannot be held accountable for that.
But anything going forward that they own it would be. Okay, I'm just a little bit unclear on what's the definition of flooding. That's line 13, 14, 15, 16. I mean, it's a little bit vague there. Is that on purpose, or is it vague to the rest of the committee? Or I'm probably the only one up here on the committee that is subject to regular flooding in Savannah. So help me understand that. What does that mean?
It means what the text said. Flood is any inundation from rising waters or from the overflow of streams, rivers, or other bodies of water, or from tidal surges or storm surges in case of hurricanes and tsunamis. So if your hot water heater in your basement explodes and you have damage from that hot water heater, that is not what is required under this law.
Inundation means, what's inundation mean by you? Or? I guess really the crux of the definition is inundation, right?
Correct.
An overwhelming flood or deluge of water, often resulting in widespread damage and destruction. That's just what I'm pulling up here on the internet, thesaurus.net.
Yes, sir.
Does that sound reasonable? Okay, I don't know.
Chairman Watson, it may help if you look on lines 21 through 36. While we define flood, these are circumstances that would invoke your requirement to disclose under the law.
So if you had to have repairs or there was physical damage.
Or the other requirements when it comes to insurance or being in a floodplain, those kind of things.
Right, that's actually already, maybe I'm wrong, but everybody in Savannah discloses whether they're in a floodplain or how many feet above sea level and all that. Maybe that's not, that's what I'm used to. Maybe that's not law, but okay.
Other questions for the author? All right, thank you. We're here from a couple other folks. If y'all want to step aside for a moment. We'll hear from Matthew Totten, an attorney with the Totten firm, testifying in opposition to the bill. Good afternoon.
Good afternoon. Thanks, y'all. In addition to being my own boss, I'm also the chair of the legislative subcommittee for the real property section. So while obviously I'm not speaking for the bar, that I've had the opportunity to talk with a lot of leaders within the real property section, real property practitioners. I think the important thing to note here, which none of y'all have highlighted yet, is currently the standard here in Georgia for purchase and sales is generally caveat emptor. The only disclosure that I could immediately locate that's required under state law is under 44.116, which is where, upon inquiry, if someone inquires about a death in the property, you're supposed to be truthful. This flood disclosure is very different, and while I understand the sponsor here was equating it to lease disclosures and so forth, I think, as the committee knows, the due diligence and opportunity to inspect is vastly different when acquiring a property. Moreover, I think what's important to highlight is, as Senator Cowsert was highlighting, the actual knowledge and some of this language in here is really just creating a new cause of action for the plaintiff's bar. What I think is actual knowledge might be different than your actual knowledge, and certainly while that definition's not out there, doesn't mean lawsuits are going to be filed. Nonetheless, I think some concerns there too is if the fact that this bill, assuming it does move forward, isn't limited in scope of time. For instance, whether it's limited to the seller's ownership, which I know that there are other states out there which have done so. I know Florida, House Bill 1049, which was passed in 2024, limits the scope to the seller's ownership. I think additionally what's worth noting here on this is some aspects of the bill, such as on lines 35 and 36, which is B7, it's something that's really open and obvious. So for instance, if somebody has a retention pond or some sort of physical improvement to the property to be an erosion control measure, a flood wall, the hurricane rocks you see on St. Simons, what have you, why are we disclosing it again? That seems redundant. It really is just another potential landmine for a cause of action. I think also the scope of, as the sponsor highlighted, of who would be required to disclose it under subsection F on lines 51 through 53. Currently it leaves it open, and whether the real estate brokers, closing attorneys, anyone else that's remotely tied to the property may have an affirmative duty. As everyone knows, there's a lot of parties that are involved in a real property closing, and that's silent. And I would suggest if this did move forward in any measure, that language be limited to excluding from this bill and or any real estate broker or advisor representing the seller or party within that transaction. Finally, I did want to note, I think it was Senator Calvert's inquiry, the Fair Business Practices Act actually under 10.1.399C provides for treble damages for intentional failure to disclose. So it's not just a drop in the bucket for anyone here. Ultimately, I think this one also needs some clarity as to what is 1 to 4 family residential. As this committee knows, 1 to 4 family residential is a bit flexible in this world. Is it something that is a single family rental that's being sold corporation to corporation? Is it me selling a house to, Susie Q down the street? I mean, there is some vagueness there, whether a corporation would need to disclose it in a corporation transaction, whether it's purely a consumer to consumer transaction. But ultimately, I think this bill is a significant carve-out to what's the standard caveat emptor. So I would strongly encourage this committee to examine and consider not approving it. Thank you.
Mr. Totten, one question for me. So today, before this bill passes, if someone wants to bring a claim based on previous flood damage against a seller, would that be like a latent defect claim? Is that the only way to do that now?
It would be, but there is the aspect of if people have the opportunity to do due diligence and they do it or they waive it. For instance, if you go through an inspection, say, well, maybe you should look behind the wall.
It's about whether it's really latent.
Yeah, right. They don't look behind the wall. Well, that's their problem, not looking behind it. Now, if you deliberately obstruct it, and throw up the paint to cover the mold and then say it's not out there, then maybe that's a claim for fraud. But I think that's really what this bill's kind of going to, whether somebody's making a misrepresentation, and again, to the extent that that's an affirmative obligation, that really flies against kind of the standard here in Georgia.
Is it your opinion, based on this draft and the inclusion of the Fair Business Practices Act, are we making the exclusive remedy now for any claims of previous flood damage to be in a remedy under that act?
I wouldn't view it as being an exclusive remedy. I think it's an additional one to what's already out there.
The other one would just be a latent defect claim or a fraud claim in essence you could still make?
Yes, sir.
Okay. Leader Hatchett.
Thank you, Mr. Chairman. And when you buy or sell a home, if you're the seller, you have a duty to disclose certain defects or conditions on the property, correct?
Generally, yes, but the way Georgia law currently operates too is the seller has the opportunity to market and sell it as is. With this bill, I would surmise that even though somebody might try to sell it as is, they would still have that duty to disclose it under this statute. So,
I guess in a situation where you sell a property as is, that kind of puts the buyer on notice, hey, I might need to do my homework. But if you don't sell it as is, and you're, a typical selling to a first-time home buyer or something, what are the things that you have to disclose?
I guess that Mr. Ledford will be able to speak on to a little bit. There's generally, most transactions use the GAR forms and GAR transactions. There is a general checklist of disclosures, different structural repairs, termites, what have you. There is no affirmative obligation to, again, of disclosure in statute that I'm aware of, other than that dead body situation upon inquiry. Everything else is really a matter of contract and common law, which is generally caveat emptor.
Okay, and not to belabor a point, but
sure.
Recently, I moved recently, and when we were selling our house, I got this long list from my realtor.
Sure.
And they said, well, you need to include everything on here that you know, and I think it's a disclosure sheet that, and I was told you have a duty to disclose this. I don't remember seeing flooding on there, but is that typically on that sheet? And I guess what other things are you required as a seller if I know I have mold in the basement or I have, something? Are you aware of what that list is?
I know there is a portion as to water, and specifically because I've litigated a case on that before. It being a requirement of statute, though, I'm not aware, but I know it's on the GAR form.
Okay. And the current remedy right now, my understanding is it could be the difference in fair market value.
Yes, or
which could far exceed $25,000.
Yes, or in some instances you might be able to possibly rescind the transaction, but that's generally pretty limited.
Okay, that's all I got.
Again, not to belabor the point, so you believe with this bill passes that someone could still seek to rescind the contract, or they only be limited to the $25,000 damages and the treble damages?
I believe that they would still have those rights that are out there. Fraud, very limited circumstances can you rescind it. I've not actually seen a successful one, but I know theoretically it's possible to do so.
Yeah, and that was why I was asking those questions. I know there's remedies out there now that address this, and I was trying to see if we were making an exclusive remedy, but you don't believe we are?
I don't believe so.
Okay. Any other questions from the committee? Thank you.
Thanks, sir.
All right, next, Jeff Ledford with Georgia Realtors. I know you can answer those questions about the forms that we all see when I do a little bit of litigation on those forms, and we've all purchased property seeing those forms. So.
Well, good afternoon, Mr. Chair, members of the committee. Jeff Ledford, and I'm going to pull out my current draft of this. But with regard to what is currently required in transactions, and I'm going to answer not is necessarily just what's in the law, but what is on probably the most common forms used out there, the forms that are produced by the realtors, used by roughly about 50,000 realtors around the state, and anybody else that would like to use them, we offer them as well. So probably a very common form that you're going to see. I believe it is, and don't hold me to these numbers, but I think it's forms 301 and 305 of our disclosure forms do ask for a very similar listing regarding flood information. And this is part of kind of when you are working with your client, the seller, and you're getting the marketing ready and everything else. You have these seller's disclosures filled out. That would also include the other any material defects of the property, and that is the seller's opportunity to put it out there if they are aware. And that is the key, I think, with this is it is actual knowledge of. And I mean, we would be amenable to what Mr. Toten offered too, the language about limiting in F, not just the seller disclosing it, but any agent or actor on behalf. I think he offered the broker or representative, something like that. But again, this is something that in current practice, as an association, we are already asking most of this in those disclosures. That disclosure is not required by law. That is just common practice at this point.
Do the realtors have an official position on the bill, or are you just here testifying?
We are not in opposition, so we're neutral with the changes that have been made, and especially if if that pulling the agent or representative, the broker, as part of with the seller there in Section F, then I think that would be something even more amenable to us.
Okay. Questions from the committee? Chairman Cowser?
Jeff, I just want to make sure I've got a grip on this. On the current disclosure,
right?
Are you saying you are obligated to disclose known water damage to your property by flood or hurricane or whatever?
You're not. I don't believe you are legally obligated. I don't think the Georgia Code says anything other than the latent defects or material defects. But as part of what we have put in our forms to cover, and this generally comes to be from case law, things we might have seen in other states, just to have all parties protected in this. We have begun asking these very similar questions to this so that it is there's transparency in the transaction.
So what's the consequence of failing to disclose known water damage now? Later, the new buyer.
Contract law would govern that.
And that is sue them for fraud or something? Or?
You could, well, if I were blatantly lying about it, I said this has never flooded, and I've got receipts in my back pocket saying this flooded, and then I think, yeah, you'd have something a lot more to it. If I was a licensee and I provided a misrepresentation about this, then license law, you could actually lose your license for hiding that. Typically, you're not going to have a licensee that is going to inspect the property. They're going to rely on what the seller tells them. But from time to time, you might have a situation where somebody is actively hiding something like the dead body behind the wall, and if they were to tell their agent about it, the agent would be obligated to not misrepresent or mislead anyone in that part. If they conspired with them to hide that same dead body, then they would likely lose their license.
It just seems it might be simpler to make sure that this is included on that disclosure rather than creating, I mean, there's already a cause of action, and this just gives you $25,000 penalty plus treble damages, since this would only be. I think y'all need to be worried, because like you just articulated, if your agent knows of the damage, and sometimes y'all sell the same property several times, and you don't disclose, or you allow the seller to misrepresent, then I think you're going to be a co-defendant in the case.
That's why we, when we heard the option presented by Mr. Toten, we loved it. So that would be a nice little addition if that's appropriate at this time.
Any other questions from the committee at this time? Senator Rep.
Thank you. Hey, just a quick question. Any suggestions you might give towards this bill to make it palatable to you and move forward?
I think we've had a number of requests that have been included, some of which are timed to get our forms, all the T's dotted and I's crossed, and we appreciate that. I think what was brought up today, if that could be inserted in F, that'd be wonderful. Again, we tend to want to side on transparency and disclosure. We represent buyers as well as sellers, and we always encourage and ask for transparency in transactions. The last thing we want to have is typically in a residential sale, you have unsophisticated buyers. That's not an offense on them. It's just most people don't buy lots of houses as their individual residences over and over like you might have in other land or commercial transactions. So this helps to keep that a little more transparent.
All right. Thank you, Mr. Ledford.
All right.
Representative, if you want to come back up, come on back up here. What I'd like to do is hold on taking action today. You had a lot of questions asked from the committee. Will be helpful for me, and I think this is consistent with what everyone else has said too, is us to have a clear understanding as what the current law is, and make sure we understand what by law individuals are required to disclose now. A clear understanding as to what's on these forms that come into contract law for most people, And then finally, I think it would be helpful too to have some language that ensures that agents aren't wrapped up in these type of claims. It seems like to me we are creating a special new claim separate from our current law, which you probably could already bring a claim for this now, but you're creating a new cause of action, and we just want to make sure that that's the right path, or if we should do this differently. So I think more information would be helpful for the committee.
Okay.
All right. All right. And we'll be back in committee middle of next week and towards the end of next week and then the following week. So there's still time to, if you want to work with the committee members and get that information together. And Mr. Totten, as much as you could help, this might become law even though you're opposed to it. So from your section, it'd be better to come with some solutions and educate us on the current state of the law too. Thank you. All right. Thank you. All right. Last bill on the agenda. Going back to House Bill 161, Chairman Crow, he brought us a late substitute, which normally makes us suspect, but I'll give you a chance to sell us on the late substitute for the bill. And we're working off of LC 620177. I know members may have to leave shortly, so we got to keep a quorum. And again, highlight in particular the changes that we see in front of us versus the bill that passed the House as well.
Okay,
The floor is yours.
Thank you, Mr. Chairman. And my committee meeting starts at 1 o'clock up in 5:06, so I will be as brief as I can. As far as the substitute, and I'm sorry, I didn't keep a copy for myself. I gave the 01s and 2s, so I don't have the LC, but I take your word for it, what it is. That was some cleanup from PAC that Robert Smith had worked with us on. Not necessarily material to the function of the bill, but just some cleanup language. I tried to clean up the definition of domestic terrorism and the penalty for it. One was in 1611-220 and one was in 1611-221. So when we did this bill, we thought we'd try to clean that up at the same time. The way it was done, Robert had a suggestion of a better way to do it that would work more efficiently for them in prosecuting it. And so he got that language. I got it early or this morning, and fortunately Legislative Council was very kind and they were able to get it done in a substitute real quick before the committee meeting, just so we'd have that in front of y'all and not have tried to do it as a rule substitute. But those changes were pretty simple. In section 2.1 on page 4, it added that definition for assassination and removed the definition for domestic terrorism. And then in section 2.2 on page 6, it added the crime of domestic terrorism and the penalty all into 1611-221. So that was the changes that were in there that PAC had proposed. As far as the bill itself, what it seeks to do is currently the GBI, the director, assistant director, with oversight from the Attorney General, can issue administrative subpoenas for the production of very limited subscriber information for telephonic and computer accounts for certain crimes. This would add a few crimes to that to include domestic terrorism, terroristic threats, as well as swatting and harassing phone calls. So those new crimes of swatting and domestic terrorism, it would add those, as well as harassing phone calls, terroristic threats, just because the way these crimes are committed with the frequency of them and the danger that they can pose, trying to find out where they're coming from and if it's a legitimate threat or not. Getting that IP address information is, the faster they can get that, the better to stop it and to decide if it is a credible threat. So that is what the bill would seek to do, Mr. Chairman.
All right, you do have questions, Senator Rep.
Mr. Chairman, so basically it's just updating terms, and it's not a radical change. It's just pretty much adding terms and then updating other terms.
Well, the original change was to just add those other
Categories,
crimes that they could issue those administrative subpoenas for.
Mhm.
The other part was some cleanup language we were trying to clean up with some definitions and move that around while we were doing this bill. So
appreciate it.
Thank you.
Thank you.
And this is a GBI department bill, is that correct?
It
Okay.
is.
All right.
So,
Chairman
I
Cowser.
have Special Agent in charge, Sarah Lou, from the Cybercrime Unit here as well. She can answer.
And Ms. Lou, do you want to weigh in at this time, or do you?
Yes, thank you, Chairman Strickland and committee members, for your time today. I'm Sarah Lou. I'm Special Agent in charge of the Georgia Cybercrime Center, located in the great city of Augusta, Georgia. And this is a legislation that we feel very passionately about. We were requested back in 2023 and 2024 to conduct multiple investigations into swatting incidents all across the state. These incidents included cyber-enabled threats. They posed a serious risk to public safety, and these targeted multiple elected officials and public officials throughout our great state. To locate these individuals that are behind these threats, time is of the essence. And right now, we don't have any tools that allow us to identify these threats in a very expedient manner. And this is not only for convenience, this is for operational necessity. So we are trying to determine the source of these threats without knowing what venue or jurisdiction they are originating from. We currently, at the GBI, hold administrative subpoena authority on child exploitation cases. So this is a process we're very familiar with. We currently issue administrative subpoenas through the Attorney General's office thousands a year for child exploitation cases. And it's important to remember that this administrative subpoena authority would only be for subscriber information from electronic service providers. So if we get a threat that is administered and executed through Facebook, through Instagram, through these electronic service providers, we are able to identify the threat very quickly with the cooperation of the AG's office through our our division director's office, and identify what IP address this originates from. This type of information doesn't typically require judicial oversight. It's typically through a grand jury subpoena, but grand jury, as you know, is not always in session. And so we are looking to reduce the threat to citizens of Georgia, to elected officials, to our communities, and to our schools by allowing us to have administrative subpoena authority for basic subscriber information. And furthermore, this also supports legislation, House Bill 268, that's currently up. It's the school and student safety legislation that is currently up with the legislature.
All right. Do you have questions, Chairman Cowser?
If I could ask just a couple. All right, so I'm very attuned to these issues. I'm a member of the Board of Homeland Security. I authored the bill on domestic terrorism. And I'm an attorney, so I'm sensitive to the fact of granting subpoena power to anybody without judicial review, which this does. I've supported it so far because of the urgency of these things, and as I understand the finite nature of what you're obtaining. It is not the content of any communications, or
Correct.
Is it? Okay.
Correct.
It is what number or what computer did this threat come from? Pretty much. Okay.
That is correct, Senator Cowser.
I'm scared when you start striking the definition of domestic terrorism. That was hotly negotiated, bipartisan, lots of issues wrapped into how we defined it, and it was a bear. It's tough to define it without being overbroad and restricting freedom of speech and assembly and protest, et cetera. So I'm nervous that we're taking the definition out of the definition part of the code on domestic terrorism, and then it looks like to me you're putting the identical language in somewhere else. Representative, is that what we're doing, and if so, why? Or are there changes that I just can't read quick enough to catch?
Yes, sir. That exact language was taken from 1611-220 and placed into 1611-221.
Do you know why?
I do not. Robert Smith with PAC would have to illuminate us on that. That was a suggestion from him.
I picked up on the definition of assassination, which makes sense.
Yes,
So
sir.
let's be clear what we're talking about, and that was an added definition. Okay.
And
All
he's, yep,
He's signed up to speak. He's going to speak next,
Okay.
so we'll let him address that directly.
Well, thank you.
Thank you, Senator Cowser, for your work on Homeland Security and your work with domestic terrorism. I will defer to Robert Smith from PAC for further explanation of that section, Part 2 of our bill. You've hit the nail on the head. There are threats in Georgia, cyber threats, that keep me up at night. This is one of those threats. Chaos, confusion, public safety, thank God, has not been affected thus far, but it is not if, but when. So we appreciate your attention to this matter and the fact that the time is of the essence in these investigations.
Here are questions for the author or Ms. Liu, Agent Liu. Well, we'll call Mr. Smith up. I remember, Chairman Cowser, when you brought that bill to the House, I was in the House Judiciary Committee, and I think you came, we did. You finally came in and said, whatever y'all want to do, I'm here. I remember that.
Water it down all you want. I remember those debates as well, starting in here, and that was, I believe, Senate Bill number 1 that year, if I remember correct. And Robert Smith from PAC, and I apologize that this is late arriving. This is something I should have caught in the House. There was a change made when it took the definition and made it into the elements of the crime, and that is a subtle change, but the wording, there were a couple of words that were dropped and a couple of things that were shifted around that actually made it more difficult for us to be able to prove and prosecute domestic terrorism. What I did, and I'm honestly not trying to hide the ball at all. You use the word assassination. Assassination's not defined anywhere in Georgia code. So I used a definition that is a amalgamation of a couple of states and federal law to come together with a common understanding of what assassination means. I then took the elements of the term and the definition of domestic terrorism and made it into, rather than a listing, into basically prose, into a paragraph of what you have to do. And there should not be a difference. There should not be any substantive difference. Everything that is in the definition right now, anything that's in 220 is in 221. The difference between the House version and your version is that I've made it such we can actually use it. The House version, and the thing that got me the most concerned was there was a second specific intent that would be required, not just showing that the person was trying to cause bodily injury, but also while trying to cause bodily injury, they also had the specific intent of trying to intimidate. And whereas what I've put forth to you in the proposed language is that they would have to have the specific intent, and while they had that specific intent, the result was, which I believe, Senator Chairman, that was your intent in Senate Bill 1, and I was trying to be as true and as honest and preserve what you had come up with and what was so hard fought that year.
Chairman Cowser.
That makes sense. But what I still don't get is why are you moving it from the definition section to the 221? I mean, it looks like maybe we don't get to see it, but the House language unintentionally changed the definition to make it weaker. You're strengthening it back the way that we had it with SB 1 years ago. But still, structurally in here, you're striking through the language in the definitions portion, and then you're building it into, I guess it's 1611-221, which is the crime itself.
Yes, sir.
That what we did back in the day was we said, you know, here's what happens to you if you do domestic terrorism. Then you had to refer back to the definition section to see what was domestic terrorism. Now you've taken out that definition to refer back to, but did you just move it?
Yes,
to
sir.
The crime?
Basically, right now the law says don't commit domestic terrorism. If you're found guilty of committing domestic terrorism, here's the punishment. And I believe, and I don't want to speak for the author, but I believe the intent was to, rather than simply say don't commit domestic terrorism, was to put it together and say don't commit the following thing because that's what we call domestic terrorism.
Okay.
It's not, and once again, I don't want to speak, but
the original issue was it was defined in 1611-220. The penalty for that crime, the actual crime itself, was in 221. And so when this code section referred to 1611-221 as one of those crimes that could be issued an administrative subpoena for, it was confusing as to what that actually was, because all it had was the penalty for domestic terrorism and didn't have it in
include
there.
the definition in that statute.
Right.
You had to reference back to where the definitions
Yes, sir.
were
So
like we do all the time.
we talked to Jenna, I talked to Jenna Doldy in the Legislative Council about how we could structurally fix that without changing anything substantively, just so that the crime we were referring to was the crime of domestic terrorism. And she suggested a fix that we did, that Robert caught that there were some changes there that shouldn't have been made, and I'm appreciative to him for that. And so we wanted to go back and fix that, and this was his suggestion on the best way to do that, because I don't want to change the definition or domestic terrorism at all. I just want to make sure that when we're referring to it, we're referring to the right place. in the code section.
Mr. Hennessy, do you want to weigh in at all? Or are you able to weigh in at all just to make sure we're all seeing it correctly?
From what I got today, and I compared it with the law as it currently stands, it basically does just take the definition from there, moves it down into that code section, and instead of saying domestic terrorism means, it turns it into the active, a person commits domestic terrorism, and the language tracks basically after that point.
All right, thank you. All right, any other questions from the committee? No one else signed up to speak on the bill. What's the pleasure of the committee? Motion to pass from Chairman Cowser. Is there a second from Leader Hatchett? Any discussion? All those in favor of the motion, please raise your hand. It is unanimous. Who's carrying the bill in the Senate?
Chairman Albers.
All right, Chairman Albers. All right, thank you. Those are all the bills on our agenda. With that, we are adjourned. Thank you.